All right. Here I got my amended complaint, and this is what I received today from the attorney, which is who is fighting in court. So it says that the pursuant defendant might moves to dismiss the plaintiff's most recent complaint with prejudice and is therefore states the plaintiff has filed the amounts of third amended complaints against the defendant. Like his previous pleadings, this complaint is handwritten and are legally eligible. Plaintiff starts with a nearly incoherent diatribe of facts regarding several arrests for trespassing. Sprinkled amongst these paragraphs are references of forced medication, physical abuse, and hands of unidentified individuals, and a celebrity, Brooke Hogan, who allegedly loved plaintiff. Adding to the confusion, plaintiffs have separated the remainder of his complaint into two counts, neither of which is labeled. Count 1, plaintiff makes vague allegations of harassment and obstruction of justice. He concludes by asserting that his interactions with law enforcement have been burden on my human rights. Is even more incoherent. It appears directed at plaintiff's prior detention at an unnamed mental health facility. With respect to plaintiff's complaint as a whole, there are numerous procedural defects, including failure to allege jurisdictional information, failure to identify the capacity of which Sheriff Scott is sued, and failure to provide the required statutory notice under Florida statute. Apart the plaintiff's complaint and unintelligible combined, these defects make it impossible for Sheriff Scott to file a meaningful answer. Plaintiff's suit should therefore be dismissed, and this with time prejudice to start. Plaintiff has not provided required statutory notice under Florida statute. The provision sets forth that the states waiver the sovereign immunity for suits against government initiatives. It provides a pertinent part that an action may not be instituted unless the claimant presents the claim in writing in an appropriate agency and also presents such claim in writing to the Department of Financial Services within 3 years of the claim occurs. All right. The notice, I've already turned in a paper. I printed out the email that I sent them, and I handed a copy to downtown, and I handed a copy to his lawyer firm, so law firm, whatever the hell they call it. So I don't know why he's acting like I haven't sent anything to the Department of Financial Services, which that I've already handled. All right, this is why I'm gonna put in a motion for a summary judgment. If my motion for the summary judgment is denied, I already put a motion for a jury trial today, which I should just allow that motion to sit. I don't know. I'm gonna see what I'm gonna do, but these notice requirements are not a mere technicality that are conditions precedent to filing suit against county officials. Like renders complaint legally void. Plaintiff has not complied with these notice requirements. Consequently, his claims against the extent they can be asserted must be dismissed. All right. Holding that the failures alleged compliance with the pre-suit required warrants dismissal, plaintiff has also failed to plead capacity, which is pursuing relief against the Florida Constitution creates with each county that describes that the Constitution of Florida are the exclusive remedy of injury or damage suffered in result of an act, event, of omissions of employer or agent that states the subdivision or constitution officers and actions against the constitutional officer of which the office employee of the agent is employed. Accordingly, the only proper defendant here is Lee County and his official capacity, explaining the under Florida law the proper parties such an action apart these procedural hurdles. Plaintiffs have also failed to comply with Florida, which requires a pleading to contain a short and plain statement of the ultimate facts, showing that the pleading is entitled to relief. Plaintiff's complaint has no discernible structure and its extent its allegations understood. Plaintiff has not given an indication as what legal theories are being pursued. Such confusing and conclusionary allegations fall far below Florida pleading requirements. The outset of the suit, litigants must state their pleadings with sufficient particularity for these for these plain showing short contain a short and plain statement of ultimate facts showing the pleader is entitled to relief. Plaintiff's complaint has no discernible structure of the extent and his allegations can be understood. Plaintiff does not give any indication as what legal theories are being pursued. Such confusing and conclusive allegations fall far below Florida's pleading requirements. Outsets of suit, litigants must state that the pleadings were sufficient, particularly for a defense to be prepared. As a plea, the complaint deprives the opportunity to properly answer and prepare a defense. To say merely the complaint is not pled and is coherent, although the plaintiff's proceedings pro se, it is not permissible in litigants submit disorganized assortment of allegations present with here. According to plaintiff's complaint does not comply with rule, dismissal is warranted on this ground. Finally, the case should be dismissed with prejudice. We are now on plaintiff's third amended complaint. Remains unable to follow even the most basic pleading rules as the most point certain. The procedural Alright, so he's telling me that it's not right. As court explained, Barrett, although there is no magical number of amendments allowed dismissal of the complaint, alright, it says that it's not filed correctly. Alright, y'all.